Hey everyone, this is David Glazer, and welcome to today's webinar on why documentation deficiencies do not automatically create an overpayment. Those of you who know me know I generally talk really quickly. I'm going to try and go super slowly today, although in light of the Olympics, I'm a little worried that if I talk slowly, someone's going to think I'm not trying hard enough and try to throw me out. But I'm going to smash through that and make a sincere effort. As usual, we try to keep our announcements to a bare minimum, but we have so many people on this webinar who have never been on one before. Those of you who are frequent listeners, take a minute to zone out. So if you've never done this before, you can ask questions. If on the right-hand side of your screen, you should see three boxes, one of which says chat in the upper right corner. If you click on chat, you can then type in the bottom right corner where it says chat, questions to me. And feel free to do that at any point during the course of the webinar. At the end, we'll try to go through the questions, and I might even do it somewhere in the middle. If I don't have time to conquer the question during the webinar itself, we'll see what we can do about answering it afterwards. Second housekeeping thing is that sound sometimes gets choppy over the noon hour, and that may not be something that any of us can really control. If you have trouble, there's a phone number you can dial into. Robert Nelson types that in the chat box so you can see the number there. Feel free to use it if sound gets all hinky. And in addition, you will get a copy of this webinar. You'll get a tape, or a CD, I guess, in a few months. Try that again. In a couple of weeks, you'll get a CD, and you can listen to it there too if you don't have a life. All right. Only other housekeeping announcement is our next webinar, which will be September 12th, is going to be everything you can think of related to imaging. We'll be playing John Lennon's Imaging All the People in the Background as we talk about what you need to know about joint ventures for imaging, the rules regarding the anti-markup rule, so the physician component, the hospital component, all that stuff related to imaging, and that will be on September 12th. So let's dive into this. I'm going to be talking about something that may contradict information you've heard before. And I don't know if your brain is like mine is, but my brain tends to give undue credence to the first data point that it gets. So if someone tells me that the reason the sky is blue is because it's scattering of light, I will give that credence over any subsequent information that comes in, even though if you think about it critically, the fact that I happen to read the first thing in a science textbook or in a newspaper doesn't give it any more authority over subsequent information. And so what I'm going to ask of you is to keep an open mind as you hear this, and don't think that just because some of the things I say contradict stuff you've heard before, it must be wrong. Now, the converse or the inverse or whatever verse of this is also true. Just because I'm saying it doesn't mean it's right, and we'll go through that a little bit too. I could be completely wrong, and if there's something I say that you think is wrong, please use that chat box to call it to my attention, because either you'll be enlightening me or I can get a chance to try to explain why I think I'm right and I'm wrong. But one of the things in the healthcare industry right now is that this cartoon is far too realistic. Uh-oh, Danny, sounds like the monster in the basement has heard you crying again. Let's be real quiet and hope he goes away. All kinds of people have an incentive to fake you out, and they often try to do so either intentionally or some of them are just doing it inadvertently. And it's good to be a cynic. You've got to be extraordinarily skeptical of advice you get from people. You have to ask if something is a requirement or if it's a guideline. A client got a letter. Last thing I dealt with yesterday was a client in a distant state. Got a letter from an attorney that said, hey, I'm representing this person in a personal injury case. Please send your bills to me. And by the way, it's against state law for you to put this person into collection. So the client called me and said, geez, I don't think it is it, David? Now, I am not a collection attorney. That's not my area of expertise. And I didn't know the answer to this question, but I knew this. I could read the letter from the lawyer, and the lawyer didn't do any citation to authority. And that was a warning sign to me. If someone knows a law or a rule, they should be able to point to that rule and give it to you in writing. So if someone says you have to do this, some questions to ask. Are they talking about a requirement or a guideline? And when we're talking about evaluation and management services, note that they're called evaluation and management guidelines. Someone should be able to give you a copy of the rule. If they can't, be suspicious. If they can, that doesn't definitively answer the question, because the next question is that rule properly promulgated? Is it a valid rule? If it's guidance from a MAC, or what used to be carriers and intermediaries, but now Medicare administrative contractors, that doesn't make it binding. And so there's a second question. This is really a question for the lawyers in the crowd. And is the rule effective? But that job falls to us lawyer types. Relax, Worthington. As the warm, moist air from the jungle enters the cave, the cool, denser air inside forces it to rise, resulting in turbulence that sounds not unlike heavy breathing. That sounds very scientific and authoritative until you look at the pile of bones in the lower left in the cartoon. This guy doesn't know what he's talking about. Just because someone sounds smart doesn't mean they have any idea what's up. And in my case, the fact that I don't sound smart doesn't mean I'm wrong. So you got to be careful and look at the substance of what's going on. Take Henry Kissinger to heart, trust but verify. So with that as lead-in, let's look at, I guess this is a tribute. John Lennon keeps creeping through here, so let's imagine this. This is completely made up, never happened. Never have I had a client who called me up and said that they had a doctor who saw 1,700 patients over the course of a couple of years, and they have charts for about 1,200 of them. And by the way, where they found the charts were in the trunk of this doctor's station wagon, scribbled on scrap paper, basically. So that's what they've kind of got on the missing 500 people are literally grocery bags with notes written on them in this completely made up situation. So what do? Do you refund the money? Or let's say you've got an internal chart review and you find results that look like this, with Dr. A got 13% of her charts undercoded, she's got 76% that are right, and 11% are overcoded. Or Dr. D, who's got none undercoded and 81% overcoded. What do you do in this situation? Well, the government is sending you a subliminal message. Here's what they want you to do. My subliminal message didn't work that well, but that was supposed to be subliminal. They want you to refund that money. And it's based on the premise that if it isn't written, it wasn't done. And that's great advice, but it's not the law. The law is that Medicare payment is determined by the content of what you do, not by what's in the medical record. Now, important giant asterisk here. What I'm going to talk about is Medicare specific. Medicaid has different laws in every state, and what I'm going to talk about doesn't necessarily apply to Medicaid in your state. In fact, a number of states have specific documentation requirements in their statute, and so this won't necessarily hold true for Medicaid. It will in some states, but it won't in all. Private payers. I've seen some Blue Cross Blue Shield contracts. I was looking at a payer contract in Idaho, and it was, I think, Blue Cross Blue Shield of Idaho that was requiring documentation now, and said that a lack of documentation gives them the ability to come in and assert there's an overpayment. So you've got to look at your private payer contracts because they could mess with what I'm going to say. This is Medicare specific. But if we're talking about Medicare, the documentation guidelines are just that. They're guidelines. So how do I know that? And we're going to go through this kind of nice and easy so that you can decide whether this argument has any merit to it. So the first place to look, it's always good to think about the hierarchy of the law. The top of the hierarchy is the statutes. Below that are the regulations. And the way you kind of know that, if you're a non-lawyer, statutes are going to say things like Act, the Social Security Act, or it might have a USC code. That's the law, top dog. Below the law are regulations. And when you hear someone talk about the Code of Federal Regulations or the CFR, those are regulations. Those are below the statutes and authority, but still regulations have some meaning. Then there's policy guidance in the manuals. And I try to be really careful with my language and not refer to some pronouncement made by a MAC as a regulation. Similarly, I try not to call anything that's in the manuals a regulation, because I think wording here matters. So things that are in the statutes and regulations are pretty much guaranteed to be effective. Well, things in the statutes are effective. Things in the regulations are effective unless they contradict a statute. After that, all bets are off. So here's what the Social Security Act, the law, says. No payment shall be made to any provider of services or other person under this part, unless there has been furnished such information as may be necessary to determine the amounts due the provider. So if you look at this statute, what does it say you have to do to get paid? you have to furnish information to determine the amounts due to the provider. Note what the statute does not say. The word medical record doesn't appear anywhere in that law. It doesn't say anything that's not documented in the medical record cannot be considered in the determination of proper payment. You have to furnish information. So presumably you could do it via testimony, via a letter, via circumstantial evidence, something that you could infer. So the law is not backing up this notion of if it isn't written, it wasn't done. Now, I'm going to jump to a case that used to be in overpayment cases. This case was cited regularly in Medicare letters. I haven't seen it as much. Back in the 90s, I used to see this all the time, and I think it's worth mentioning because it's it's an interesting case. It was an anesthesiology case, and the clinic had billed quite improperly for things like they would bill for floating a Swan Gans catheter when what really had happened was monitored anesthesia care. And the court said, look, these claims were inaccurate, and so even if it was the defense was, well, they were just merely an unartful description of the service that was provided, so don't hold us to it. And the court said, look, your claim inaccurately described the service that was provided, and that makes the claims false, and they imposed false claims liability on this clinic. Well, that's different from what's happening in the evaluation and management world, because here, we're talking about cases where you're billing a 99214, a level 4 established office visit, and the documentation supports a 99212, a level 2 established visit. That, if in fact a 4 was billed, the claim accurately describes the service. The question we're talking about is whether there's documentation to back it up. So that anesthesia case is basically irrelevant to our analysis. Now, the next few slides are some of the most important because they really lay out this argument in kind of plain English. So when the E&M guidelines first came out, way back in 1995 when I was a young pup lawyer, the CPT assistant came out and said, it's important to note that these are guidelines, not a law or rule. And remember how we talked about our hierarchy of laws and regulations, and I would use regulation and rule interchangeably. Well, these guidelines are not that, says the CPT assistant, and it notes physicians need not modify their record-keeping practices at all. Super important statement. Then CMS, which was then called HCFA, the Healthcare Financing Administration, came out with this statement, and it's very hard to find this statement online. I have a copy of it, thanks to a very smart and good person down at a client of ours, who kept this and brought it to my attention. So thank you, Leon Raby. But this question and answer sheet has the question, are these guidelines required? And look at the answer. No. Physicians aren't required to use these guidelines in documenting their services. Now, I recognize that when you get audited by a MAC, they come in and say you're supposed to use these guidelines. But CMS, then HCFA, was quite explicit in saying you don't have to do this. And if you read the rest of this paragraph, you can see that they're setting up a sort of a safe harbor. This might be a great way of doing the documentation, but you don't have to do it. Varying formats of documentation will be accepted by the carrier as long as the basic information is discernible. Now, another one of the questions was, do these guidelines change any of the definition of the codes? And they say no. The way you choose a code hasn't changed since the codes were introduced back in 1992. So the introduction of these guidelines was not changing the way you determine code selection. So how are these guidelines going to get used? Now, this answer is not the way the world works today, but it's really interesting. According to this, look at the last sentence. If the documentation isn't sufficient to support the level of service, the carrier will contact the physician for additional information. Note that it doesn't say if the level of documentation isn't sufficient, the claim is denied. That's not what's supposed to happen. It's supposed to be additional information is sought, which would give you the ability to demonstrate that the service was actually provided. Is this what MACs do? No. Is it what they're supposed to do? Yes. And then this last interesting question, what are the chances of being reviewed? Now, they do reviews differently today, but what's interesting is the first sentence here. Review is done only if evidence of significant aberrant reporting patterns is detected. Now they do random reviews, and so the reality of this has changed, but the important point is why they're saying this. The point they're getting at is they're trying to figure out what's going on in situations where they don't believe the data. Now, I'm going to give you a few more citations. These are from various manuals, and you'll see some of the cites, because you might have situations where you're going back into the distance, so some of the cites are to manuals that aren't really maintained anymore, like the Medicare Carriers Manual here. The new manual version of that is the Financial Management Manual. So there's some instructions in there about when an overpayment exists. And according to the manual, one situation where there's an overpayment is if the physician fails to submit documentation to substantiate that he performed the services billed, where there is question as to whether they were actually performed. So note that it's not simply failing to provide documentation. It's failing to provide documentation when we don't think you really did the work. So the ultimate question really is, did you do the work or not? If you look at the Carrier's Manual or at the Claims Processing Manual, it instructs physicians to select the code based upon the content of the service. If it was true that if it isn't written, it wasn't done as the law, then you should select the code for the service based on the content of the record. That's not what it says. Now, the next slide is way old. This is language from what was then Travelers Insurance Company, which has been, I'm forgetting my history. I think that's now part of WPS. It's moved so many times. But it was a Medicare carrier at the time. And note that it says that physicians should pick the level of service. And I put this in here in part because I want to tee up the question of who should pick a code. Should the doctor pick a code, or should a coder pick the code? The answer is you can choose who you want. There isn't a legally required answer, although here Travelers thinks that the physician should. I personally recommend that the choice come from the physician. And the reason is what's articulated in this section. Basically, office staff are not normally able to assess the difference in the amount or intensity of work associated with each encounter. And since the physician's responsible financially and legally for the claims, it's essential the physician actually code for the services provided. And this is just more backup for the idea only the doctor knows what happened in that room. So now, it's not just CMS who has offered some thoughts on this. At some point, the Office of Inspector General did a report on physician use of new visit codes. And they said, accurate coding is achieved when doctors select codes for which consistently fit the services they actually provided. So once again, they're not talking about the service documented, but rather what they did. And I'm sorry if I'm beating you over the head with this, but it's important. This is all about providing support for a concept that I know is a bit contrary, and I am a big believer in giving the documentation to back this up, so hence the slog. Here's what CMS says in their definition of the proper CPT code definition. And so you look at the green text here. When a CPT code is associated with the descriptor submitted to Medicare, all services described by the narrative should have been performed. And that's coming from the Medicare Claims Manual, and then a manual which I have to admit I had never heard of. I thought I was a manual junkie, but until I was trying to find where this Medicare Claims Manual language went, I had never heard of the Medicare Contractor, Beneficiary, and Provider Communication Manual, but it's out there, and that's where this language appears. And it's one where the acronym is too long, let alone the actual name. This is also going way back in time, but when the OIG came out with a report way back in 1993, CMS noted that just because you've got poor documentation doesn't mean that you didn't have medical necessity for a visit. And once they were kind of talking about poor documentation doesn't mean a service wasn't billable. So even CMS has acknowledged this in a report that was published, okay, this is sad, almost 20 years ago when I was a really young pup lawyer. Now, perhaps the most important case is United States versus Krizak. I'm never sure if it's Krizak or Kryzak. Dr. Krizak was a psychologist in the Washington, D.C. area. And his claims, he worked in an office, small office. His wife ran the office and was responsible for the coding. And his wife made the decision that basically she would assume all of Dr. Krizak's visits were the highest level of psychology visit allowed. And you bill psychology visits based on time. I think there were 50-minute, don't quote me on this, I think it's a 50-minute, she assumed encounters lasted 50 minutes unless specifically told otherwise, and he generally didn't record the amount of time. Well, it turns out there were at least 3 occasions where he billed more than 24 hours in a day. And for some reason, people were skeptical of this. I think disregarding the fact that he could have been on a plane traveling west and maybe gotten more than 24 hours in a day. But it gets to court, and the judge has to decide how to handle the situation. So we don't have good records right now for Dr. Krizak to know how much time he actually spent on any given day. So if the principle of you have to document to get paid were true, all of his claims would have been false because there wasn't good documentation to back them up. But that's not what the court did. What the court did was said, look, we know he's a hard worker. Everyone agrees he's a hard worker. A hard worker is going to work 8 hours in a day, I think. So I'm going to give him credit for 8 hours in a day unless there's clear evidence he wasn't even around. Now, if he wants to go over 8 hours in a day, I'm going to want to see some sort of evidence, from a calendar or something like that that supports the notion that there was more than 8 hours of work. And really, in order for a claim to be false, I'm going to need proof that the work wasn't done. So if there was more than 24 hours in a day, those claims are clearly false. Very interesting approach, and basically a very pro-physician approach to things. And this case provides the foundation for saying that the real test is, do you know that the work was done? And actually, this is interesting because this one puts the burden on the government to show that the work wasn't done. This is an extraordinarily good case. Where the burden falls, I think, is a little less clear. It might be on the burden might be on the physician to demonstrate that the work was done based on the statute. This case really does support the idea that the burden's on the government to show that it wasn't done. Now, there's a bad case that's out there, and it came out of Oklahoma. It's an emergency room physician case. It's from 1998, so this is a pretty old case. And this was a physician ER group where the coding, actually the group ran kind of a coding company. And the coders said that the physician who was in charge of the company wouldn't let them talk to the doctors. And there was evidence that the codes were higher than the service that was billed. In that case, it appears that there was no argument made that if it isn't written, it wasn't done is not the law. So, but more importantly, there was pretty strong evidence that no one made any inquiry as to whether this was allowed to make an inquiry into whether the services were really done. And it seems like what in essence was going on is that the defendant knew that the services weren't being done and hence squished any attempt to validate the codes that were selected. So the bad case is A, distinguishable, I think, on the facts, and B, no one made the legal arguments that we're talking about here. But you need to know it's out there. Now, whenever you're talking about evaluation and management coding, it's important to remember time, because time can become the belt and suspenders that can save you when your history exam and medical decision-making are missing. Technically, you're only supposed to use time if more than half of the visit is counseling and coordinating care, but I think that time does become a decent approximator. If you know a visit lasted a half an hour and it was for an established patient, I'm going to feel pretty good saying that a 99214 is kosher for that. And actually, a 99215 might be almost justifiable because a 214 is 25 minutes and a 215 is 40, and it appears that rounding is appropriate. So when you get to 32 and a half minutes, a 5 is probably all right. So what's the bottom line on the role of documentation? Well, it's great advice, but it's not the law. Now, I know some people are thinking, I don't want any doctors to know that they don't have to document. And I get that. And in fact, I am not advocating blowing off documentation. I'm not advocating stopping reviews of documentation or educating physicians about these guidelines, because in the event of an audit, demonstrating that the service was done if you have poor documentation is both challenging and expensive. You're going to have to pay me, and I'd like to think of myself as cheap, but it's a lot cheaper to not pay me at all. By the way, if you ever have to pay me, remember you might have insurance coverage for it, so just throw that in the back of your mind that A lot of audits have, like a lot of malpractice insurers have free overpayment insurance that go along with it. So keep that in the back of your mind. But you don't want to have to pay someone to defend it. It's better to document. But the point I want to make is if there's an audit, you ultimately get a chance to have a hearing. Why is that? If it really were only what's in the record that mattered, we wouldn't need to go in front of a judge and have a hearing. You could do all of those reviews based purely on the paper. The whole existence of a hearing process is almost per se proof of the fact that you get to supplement what's in the record. Now, in the event of an audit, a carrier or a MAC is going to use either the 1995 or the 1997 guidelines. They're supposed to use both, actually, and choose the result most favorable to the physician. In my experience, they often fail to use both. Sometimes that matters and sometimes it doesn't. But bottom line, documentation isn't definitive. Now, let's operationalize this a little bit. So, back to our third slide or whatever it was. If you've got this as audit results, you've got Dr. A, she's doing a pretty good job. You've got Dr. B undercoding like a mad doctor there. Dr. C overcoding a bit. Dr. D, yikes. And Dr. E, who was the president of this group and using the scientific random code allocation technique, just picking one at willy-nilly, which allowed a third of them to be high and a third low and a third right. So what do you do, really? Well, here's what I'd say I would do. So first off, I think there are two mistakes on this slide, all right? And this mistake is not that 33 plus 33 plus 33 is only 99. That's just rounding. The mistakes are, I hate the word audit. I want to banish it from use. I want to call these things reviews because audits are more scientific than this. And if you think about it, we haven't determined whether the service was really done or anything like that. This isn't an audit, it's a review. So that's the first one. Second thing, undercoded and overcoded are terrible descriptors of what we know. What we know is that the documentation exceeds the code that was billed or the documentation doesn't support the code that was billed. That's the only thing we know. There are a variety of things that could be true. You might have a 99214 documented, but the person really did a 99215, right? We don't know. And so I want to label these things based on our actual knowledge, and our actual knowledge is just what the documentation says. So that's the first important thing. Next, we got to figure out if we're going to refund the money. So how are we going to do that? What on earth are we going to do? Well, the big question, and so here's, if you're just looking at this, which doctor on here is the worst? Who are we most likely to need to refund money on? And I don't know that, my premise, I don't think you can tell off of this. You might think Dr. D is the worst, all right? But that may not be true. Even though Dr. A looks pretty good, but I might be able to come up with additional data which will change your whole view on things. So let's say, for example, that it turned out Dr. D, well, we'll come back to this one in a second. Let's jump ahead for a moment. The big question I want to ask is, was the work really done? And how are we going to figure that one out? How do you figure out if the work was really done? Well, I want you to think about that one for a second. Before I go on to the next slide, take a second and think about how you would determine if a doctor really did the work for a service that was billed. And the reason I want you to think about it is I want to see if you come up with anything that's not on my list, because if you do, I want you to send it to me. So here are the techniques I've thought about to come up with. So first thing, you can talk to the doctor, obviously, and talk to the people around the doctor. You can talk to the nurses and staff and see if they think the work is really being done. A variant of that, we've had people sit in on some encounters with the physician and see what the doctor does and compares it to what the doctor writes down to see if they're different. Because if that visit, if the person fails to document a bunch of stuff, that's interesting. That's a piece of an interesting data point. You can talk to patients. Obviously, that's a last resort. You don't really want to be picking up the phone and calling patients and saying, hey, did this really happen? Although sometimes patients will call you, and you can find things out that way. You can look at most groups right now, most health systems and groups look at coding distributions. And when I say coding distributions, what I mean by that is taking the E&M visits and graphing them out in a bell curve fashion to see if the bell curve looks normal. And you might think, well, if the distribution is normal, we're good. But, and this is a really important point, you can have a perfectly normal distribution where someone has very few 99215s, a few more 4s, a whole bunch of 3s, fewer 2s, and a fewer 1s. Nice bell curve, looks normal, and they're committing fraud. What's actually happening is that they've got a perfect bell curve distribution of how they code, but they're just seeing way more patients than they should. So the last one, to me, is the single most important data point. If there was only one thing I was going to know, it was RVUs, because that tells me how much work the doctor is doing. And if he or she seems to be doing the amount of work based on the scheduling that they're there, I'm inclined to believe the work is really happening. By contrast, if you've got someone who's got 3 times the 90th percentile number of RVUs, I'm going to be pretty suspicious that the work was really happening. I might be able to be convinced it was done, but I'm going to have a much higher level of skepticism. So if I think about this back in terms of Dr. D, what if Dr. D was at the 50th percentile for RVUs, but Dr. C was at the 3 times the 90th percentile, or Dr. B was? I'm now, or even Dr. A, I'm much more worried about their coding than I am about Dr. D, even though Dr. D's documentation bites, okay? So RVUs to me is an important part of any review, and I would actually say it's more important in some ways than the documentation. Documentation is important as a risk management tool. I think RVUs are a better detector of fraud. And I would note, many of the audits that you see out there are triggered by either RVUs or they do go to that sort of coding distribution. You bill more 99204s than anyone else in the area of your specialty. Now, if you ever choose to hire an outside person to come in and help you on your E&M coding, I want to just toss out a couple of quick thoughts. First, do you use the attorney-client privilege for that review? I am inclined to do so, but not for the reason you might think. I don't think that it's very likely that most of your reviews will be privileged, because they're privileged under what's called actually the work product privilege, and that's only useful if it's done in anticipation of litigation. So unless you're if you're in an audit, then clearly you want to use attorney-client privilege for your review. That's a no-brainer, and in the event of an audit, that privilege should hold. But if you're doing it as a risk management review, I think it's very hard to argue that you're doing it in anticipation of litigation, and so I think it's pretty unlikely that your review is actually privileged. I still would probably have it go through the privilege process, and here's why. I want a lawyer to read the report before it's widely distributed to make sure it doesn't say anything that's going to hurt you if there is ultimately litigation. Because I've seen reports come back with things like, this is suspect and may be fraud, and I don't want a report out there like that floating around unless I really think it's fraud, and even then I probably wouldn't want a report out there saying that. But so I'm in some ways I'm using attorney as editor, not as preserving of privilege. But in the event of an audit, then privilege is a real thing. When you hire a consultant, be careful to make sure you check the people out. I have seen some situations where consultants seem to think of themselves as cops, and they think of their job as getting people in trouble. And you don't want to hire someone who's going to try to get you in trouble without at least knowing it first. Okay, that was sort of a bit of an aside. As part of the review process, people often wonder, should you do reviews of charts that you've already billed in to Medicare or other payers, or should you do a concurrent review, a review before the bill is submitted? Now, I often hear people say you should never look at old claims because if you found a problem there, you'd have to refund the money, so you should only look at concurrent reviews. I don't buy that premise. I actually do buy the conclusion that it's better to do concurrent reviews, but for a different reason. I do think if you're looking at a bunch of, if you believe the documentation deficiencies are fraud, and you find a doctor you're looking at 10 charts that haven't been billed yet, and all 10 of them are wrong, I don't know how you say with a straight face that the stuff from last month is okay, but the stuff today is terrible. I would not like making that argument in front of a judge. I think a far better argument, is what you're saying is, I think that the stuff is poorly documented but really done. Then that's an intellectually consistent argument you can make about stuff that's going on today in the past. It has to, of course, be true. But I don't like trying to argue that we have a big problem today, but we're not going to think about anything that happened before today. I am worried about looking disingenuous when that happens. But concurrent reviews are far more effective. If you can say to a doctor, look, here's this patient you just saw this morning, and your documentation shows this, but you didn't get points for it, that's meaningful. And I don't know how many of you are steeped in the E&M coding, but I want to give an example that I heard early in my E&M coding life that's a really telling one. Patient walks in, and they were playing softball, and they hurt their ankle. And you've got an x-ray, and there's a note that says ankle fracture. Now, you get points for location as part of your E&M review. So the question the reviewer is going to ask is, does the note say left ankle or right ankle? Some reviewers will say if it doesn't say left or right ankle, that doesn't sufficiently describe location. Others will say, well, it's ankle, that's location. And it's important to understand that level of nuance because that can be the difference between a level 3 and a level 4. And you can magnify that over and over again. There are all kinds of places in the coding where is this a history element, or is it or a part of the review of systems, or is it a history of the present illness? Kind of where do these things fall in coding speak can affect how things are coded and can totally drive the level of determination of service. And I mention that because one level differences, like there's actually case law, or not case law, but there is an OIG report to support the notion that one level differences can't be the basis of a fraud claim. And it comes from nuances that are in here that are really hard. Well, when you're in nuance like that, getting in with the physician right away and up front is really useful. Okay, another thing to keep in mind. When you do an internal review, one of the questions that's going to come up is how do you communicate that review to your physicians? And that comes with some peril. Let's say you look at a doctor and you look at 20 charts and 19 of them the documentation was crummy. How do you get the doctor's attention? Do you say, hey, this could be $1 million overpayment? Well, if you say something like that, that's going to get used against you. What I would try to do is make sure you're putting language like this, and feel free to steal it. If you do reviews and you circulate them in writing, say something like, hey, this isn't an audit that's designed to determine whether you've been overpaid or underpaid. It's not a statistically valid sample, and we only look at the documentation without trying to determine whether you really did the work. So this is far from scientific. But in a Medicare review, they would base their initial overpayment determination just on the documentation. So this gives you some idea of how things would go. And this is a great way to allow you to educate physicians and get their attention without creating a document that can be used against you. Another question I get asked a lot is, when we do these reviews, should you keep them secret? And that's a tough question. The more you distribute them, to the extent that there's a privilege, it's probably waived, but as we've talked about, I don't think there is a privilege. But the other problem is a real one. Every person out there is potentially a qui tam plaintiff, a whistleblower plaintiff. The more people that know stuff, the more potential plaintiffs that are out there. Despite that, I generally am a fan of circulating stuff, mostly because I think if you're in an organization trying to do the right thing, I'm pretty comfortable letting people know stuff and saying, trust us. And I don't like setting up a situation where people are on the inside and on the outside of knowledge. I'm more a fan of saying, hey, we're all in this together. We're working towards the same end. Now, that is a David Glazer opinion, not law. And reasonable people can differ about that. That's just my 2 cents. Now, I want to talk about a patient complaint. This is a real story from a client. So, a client that's smarter than I am. So one day, a patient who's treated by the very productive physician leader, in this case it was a clinic, not a hospital, and this was the clinic president of a big clinic. It was a 75-doctor clinic, and this was the president. Patient calls and says, I was billed for a complete physical, but I didn't remove any clothing. So what would you do if you got that call? Now, I think for most of you, part of that, the answer is really clear. You would, first thing you do is you look at the record, right? Now, the record on this case, by the way, documents a complete physical exam. And so most people would say, well, that's it. The patient's crazy. We all have our crazy patients, and you're done. Now, that's what I would have said. I mean, frankly, I would have accepted that if I'm the clinic administrator. The clinic administrator is smarter than I am, more skeptical, and also had one new data point, which was a receptionist had expressed some concern about this doctor. So the clinic administrator went one step further. She pulled the doctor's appointment book and saw that the doctor worked from 9 to 3, had a lunch scheduled, saw 67 patients, 6 of them were billed as 99215s. And the documentation was quite good on all of these. And there was a complete physical documented for the woman who called. After additional investigation, it turned out what was going on was the doctor was using a template and had a complete physical documented for this woman who hadn't had a complete physical done. So it turns out this was the opposite. This proves that just because it is written doesn't mean it was done. You know, I admit, seen a chart of a woman who had a soft and supple prostate. And in case you zoned out there for a minute, let me say it again, a woman who had a soft and supple prostate. The use of electronic templates and things like that makes it pretty easy now for poor documentation to get carried forward. And so you have to be skeptical not just of people who have crummy documentation, you got to be skeptical of people who have really impeccable documentation and look at it both ways. All right, that's what we're going to cover on the E&M stuff. For the next 20 minutes, well, actually, that's not true. We're going to come back to it a little bit in a moment. I want to move on to just a couple of other areas that are kind of related, signatures and orders. And we did Katie Ilton, who many of you will know as Katie Burkhart, but she got married, which resulted in a name change and my inability to call her by the proper name because my brain isn't plastic enough. But so Katie Ilton and I did a webinar, I believe in April, on signatures and orders. And if you want to get lots of detail on signatures and orders, you can order a copy of that webinar on the website. But I'll do a little bit of that right here. So a note isn't signed. You got to refund it, right? No. Back to that 1995 guidance that we talked about before with a question and answer sheet, look at this question. Is a doctor's signature required on each page of the documentation? And the answer, very simply, no. The guidelines only state the identity of the observer be legibly recorded. So somewhere on there you want to know who did it. Perhaps more telling is the Program Integrity Manual, which explains what happens when a MAC looks at a chart where the record is missing. And note that it says that if the signature is missing from an order, the MAC or cert is supposed to disregard the order. I don't think that's entirely accurate, by the way, but that's what the manual says. And then, if a signature is missing from any other medical documentation, i.e. an evaluation and management service, the MACs shall accept a signature attestation from the author of the medical record entry. So what this is telling us is that the doctor can sign a record after the fact, and the carrier is supposed to accept that. And that's kind of common sense. Common sense would get you to the same place, but if that wasn't enough, here's the Program Integrity Manual backing it up. You don't need to refund money on a chart because it's unsigned, all right? Now, I talked about this a little bit earlier. The manuals are not the law. And I know this because I've had my butt handed to me in a couple of court of appeals, or actually in one court of appeals case, where a client relied on language that was in the manuals, and the government artfully said, I love this. Here's the government says, if you rely on information in the manuals that goes contrary to governing statutes or higher authority, you rely on them at your peril. So this is the government saying, you shouldn't have trusted that thing we gave you. And sadly, a court of appeals agreeing with it. It was frustrating in that particular case, but useful in another important context. It's basically an admission that the manuals aren't binding. And there's another quote on this slide from, you may remember, an investigational device case back in the 90s, and the government said in a brief to the court, hey, manuals don't have the force and effect of law and aren't accorded that weight in the adjudicatory process. If someone points to manual language, that's not binding, and the government has said so time and time again. Okay, so back to the signature thing. If you look at a cert request letter, they make it really clear that you can substantiate the record after the fact. So, going back to the signature requirement, someone tells you it's a signature is required. what you need to do, first of all, is say, says who, all right? And keep in mind now, I'm talking about Medicare. I'm not talking about Medicaid. Medicaid might have a signature requirement. You got to keep in mind the conditions of participation might be different. So for example, if this is a hospital service, let's say you're a hospital-based physician, the hospital-based or the hospital conditions of participation do require a signature. But that means the lack of a signature could get the hospital in trouble. They could lose their certification, but it doesn't create an overpayment, because this is, and you can go back and look at our April webinar where we cover this, violations of the conditions of participation don't create an overpayment. They're not conditions of payment, they're conditions of participation. And so you need to figure out, JCO may have a requirement, but that's different, and it makes it important when you ask a question, does this have to be signed? That's actually kind of a terrible question to ask, because a better way of asking the same question is, if it's not signed, can we bill? If it's not signed, is it a licensure problem? Each of these different things has to be looked at slightly differently. And I will just make this is a point to just back up the notion that if during a review you find out that someone's out of compliance with a condition of participation, the MACs are not supposed to recoup an overpayment, and the backup for that appears right here. Okay, written orders for diagnostic tests. Another thing where I've heard people say, geez, it's not written, it wasn't done. Well, there's some language, and this was in Halloween 1997. The Federal Register came out, and this is back still when HCFA was called HCFA, not CMS. And they came out with a new thing. This was when independent diagnostic testing facilities were first created. And CMS said independent diagnostic testing facilities have to have a written order. And some people said, well, that's totally unfair. And CMS came out and said, look, we're putting an extra burden on IDTFs because we think they're fraud factories. But basically, this is explaining that there isn't a requirement for written orders in settings other than an independent diagnostic testing facility. And this text explains why that's the case. Well, the obvious point here is that you don't need a written order in a physician office for a diagnostic test. I see it happen all the time where MACs deny things based on the lack of a written order, but that's completely flying in the face of this Halloween 1997 language. Okay, let's go back to E&M to wrap this up, and then I see we've got a few questions here. I'll try to get to those. So, you're thinking about refunding money on an E&M situation because you've got poor documentation. So what do you do? First off, remember, don't refund just because there's poor documentation. Now, what we're going to have to do is try to figure out if the service was really done. And the way we're going to be doing that is probably using RVUs or some model like that. We're going to say, this doctor did 2,000 RVUs worth of work. We think a normal doctor working these hours would have done 1,500, so we were overpaid by 25% or some variant like that. If that's the analysis we're doing, we don't need to do a sample of claims. In fact, a sample of claims isn't helpful at all, because all that's going to do is let us look at the documentation, and we're not interested in that. We're converting this into a question of how much did we get paid and how much do we think we should have been paid. And that isn't going to be determined off of a sample. That's going to be determined off of other criteria. Basically, I think we're probably almost certainly going to be using RVUs or time or some other factor like that. It's very important to be intellectually consistent as you do stuff. I often see people saying, well, look, we're only talking about $3,000 here. I'm just going to refund this money. You don't want to refund money in a $3,000 situation where you wouldn't want to refund it in a $3 million situation, because you're setting yourself up for trouble. Or actually, let me rephrase that. You might choose to refund the money in that situation, but you need to be really clear as you do so that you acknowledge the possible intellectual inconsistency here. And so I'm going to talk about that now. And if you choose to do a refund, how you word it is important. So let's say you've got a situation, the documentation isn't really good, but it's a small amount and you don't want to futz with looking at it. Then I would do a letter that says, look, we've discovered it. And so I'd start that off with as part of our ongoing compliance process. And then I would say, we've found that the documentation was missing. We're not sure whether the services was properly provided. It's possible that if we did a thorough investigation, we would be able to support that the claim was properly billed, but we're choosing not to do that in this case. We're choosing instead to just refund the money. Now you've explained that you're not saying you're refunding the money because it wasn't documented. You're refunding kind of out of an abundance of caution, and you've not created a precedential situation. So here are the ways, and for more detail on this, last, I think it was July, Katie, then Burkhart, now Ilton, and I did a webinar on voluntary refunds. And if you do a lot of voluntary refunding, you may want to check that webinar out. But this is a slide from it, and it talks about ways to construct your letter. I'm a fan of using that it would have been more appropriate to bill this way as opposed to another way, because it doesn't acknowledge that the way you billed it was wrong. It's just saying that there might be a better alternative. Possible issues is another good phrase. Whenever you refund money, I like to try to work in the opportunity for you to recant. I won't go into that in detail here because we did that at some length in that July 2011 webinar. I am also fond of the phrase here, the level we're confident defending, because that gets to, maybe we build a 99254 if we were back in the era of consults, and we think it's only we know we can defend a 253, but it might be possible that it was only documented at a 252, but the level we feel comfortable defending is a 252, so I think that's a good phrase. I would try to avoid using anything referring to what your attorney told you, because that could be waiver of a privilege. I also try to avoid using the term overpayment, because that seems like an admission, and I think you may choose to refund in situations where there isn't necessarily an overpayment. And really what I'm trying to do is not allow your refund to be used against you. I've had situations where clients have refunded money and then someone has come in and tried to say that the refund wasn't good enough, it was really you owe more, either a larger refund or it's a false claim. And I don't want anything in your good act to be used as a weapon against you. And so characterizing it as a voluntary refund, because this is the comfortable you feel more comfortable defending, makes it hard for anyone to use it against you. And then finally, I also try to avoid ever saying that we've fixed the problem, because problems have this magical way of repeating, so I instead refer to steps that you've taken to do it. All right, really the last point we're going to cover before I get to the questions is if you do feel like you need to refund money because you've found out that the documentation is missing, you've done an investigation, and you've said there's no way the doctor really did this work. I'll pick an example, a real-world example we worked on. A doctor, we had parking records from a physician who's at place A when services are being billed at place B, and we have a record at place A of when he left. We have the record of place B of when he arrived, and we've got bills at site B that have him billing before he was there. Not feeling so good about that, so we're refunding the money. Well, how far back do you go? If you listen to the False Claims Act lets you go back 6 years, but I don't think that's the proper test. Actually, you can go back 10 years under the False Claims Act in a wide variety of situations. That's not the right standard in situations where someone made an innocent mistake. The proper standard is a different one, and it's a statutory standard that's really confusing. So the law says that if a provider or supplier is without fault and recovery would violate equity and good conscience, the government can't recover the money. And based on this statute, which is Section 1870 of the Social Security Act, Medicare can only go back 3 years after the year in which payment was made. Now, this is really confusing. It's horrible language because it focuses on the year payment was made, not when the service happened. And it works as the year in which payment was made. So like if you have a service that was done in December of 2003 and paid in February of 2004, the government can recover that money up until December of 2007. If that claim had been paid in 2003, just like a month earlier, we lop a whole year off of the recovery period. Crazy, administratively a headache, but it's the law. So there's a second guidance out there that allows Medicare to reopen claims for 48 months unless there's fraud or similar fault. This is a rare situation where I actually tend to advise people to go back 48 months because it's easier. But the technical legal answer is you can go back less than 48 months in many situations if it's, it might be 3 years after the year in which payment was made. That's operationally so difficult that I think it can be difficult to do. And even though I've got some really good slides here with my favorite cartoon of all time, I'm going to skip that and move on to the questions right now. But, well, I will just say, how do you determine if fraud or similar fault exists? It's a judgment call. You're going to look at, oh, please, cat food. In this situation, that to me looks like fraud. It's deception. It's intentional. Let's compare that to inadvertently, Roy dooms the entire Earth to annihilation when in an attempt to be friendly, he seizes the leader by the head and shakes vigorously. Well, that's inadvertent, we know. And then this is my favorite Gary Larson of all time. Ha ha ha, Biff, guess what? After we go to the drugstore and to the post office, I'm going to the vet's to get tutored. Now, that might be fraud and it might be an innocent mistake. It depends, we don't know. And that's what your investigation is to find out. So let's whip through a few of the questions. And before I go to the questions, I will remind many of the people on here are new. And so I want to say, if you're new, first, we appreciate it if you fill out an evaluation as to what you think of this. If you have topic ideas, send them to us. And if you want to make sure you get invited to these, please, if you signed up for this, you'll be on our mailing list. But otherwise, you can always send an email to events@fredlaw.com, and we will make sure you get webinar invitations. And we'll make sure you don't get what we call internally Fred spam. I don't want you to be getting silly newsletters from us and stuff. We will keep you limited to things about the webinar. All right. What do you do? Can you touch on how a lack of appropriate orders affects questions of documentation? Does a lack of a physician order equal a denial or overpayment? And that was asked, I think, before I covered that. And so hopefully what I talked about got there. The answer is it depends. And what I would encourage you to do, we did have that webinar. I would say get the July 2011 webinar, which really focuses on orders and when they matter. Because the answer is it varies from thing to thing. Durable medical equipment is handled, so diagnostic tests, you need a physician order, but it can be standing. It doesn't have to be written. But for certain things, you need a written order, and it's too convoluted to go through right here. Can I get a copy of the question and answer from CMS about the documentation guidelines? I will see what I can do in that regard. Well, actually, these are all please send me's. So I will try to send people the stuff. I'm not seeing other questions about the actual stuff here. I have a couple. No. Well, one's coming in right now. So while we get that, I will add. Don't forget, we're imaging all the people in September on the 12th. We will be talking everything you need to know about imaging. Our October topic, if HIPAA comes out, we will do HIPAA in October. If not, we'll come up with something hopefully interesting. And I'm going to wait for 1 second for Robert to bring me the last question. And you still have time to whip them in. So I will say this about orders. I wouldn't give up unless you can find something that explicitly says it has to be written. So I think that brings us to a conclusion. Please fill out your evaluations. Thanks again for signing up and joining us. I'm going to have a correction here. If you want to sign up for future webinars, you can go to fredlaw.com and sign up on the health law email list. Or you know what? Make it easy. Send me an email. I'll get you on the list. If you send me an email, I'll get you on the list. So thanks again for joining us, and enjoy the rest of the Olympics.